Is Disha still there?
Yes, sir.
Yeah.
Section 376C, sexual intercourse by a person in authority. Whoever being in a position of authority or in a fiduciary relationship, or a public servant or superintendent or manager of a jail, remand home, or other place of custody established by or under any law for the time being in force, or a women's or children's institution, or on the management of a hospital, or being of the staff of a hospital, abuses such position or fiduciary relationship to induce or seduce any women either in his custody or under his charge or present in the premises to have sexual intercourse with him, such sexual intercourse not amounting to of offense of rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 5 years, but which may extend to 10 years, and shall also be liable to fine.
Yeah. So why is the Tukaram case important with respect to this section? Because in Tukaram's case, they could not establish whether or not it was rape. There was enough evidence, it may have been incorrect, but there was evidence to the effect that the sexual intercourse, because sexual intercourse was eventually proven, because we do see that there was sperm particles on the on the clothes of the woman. So there is an aspect, that's how you prove sexual intercourse. There can't be random sperm particles on the clothes of the woman, right? There is some level of sexual interaction that has taken place. However, whether or not it was consensual, she said she had been raped, but forcible entry could not be found. But there was some sexual intercourse, but it was consensual in nature, is what the final conclusion was. So this nearly 33 years later, this law is put into place, where even if it is consensual, because this person is in a position of authority and they are abusing their position of authority, and they commit sexual intercourse with the woman with her consent, but the consent is through the abuse of that authority, it will be considered rape. It won't be considered the same level of aggravated rape as we learned in 376, where similar circumstance occurred, because that was proper rape against her will, against her consent. In this case, it is sexual intercourse. Sexual intercourse on the basis of abuse of position. So Prakhar's point of, if she consensually has sex with her guruji, it would fall under this section, because it is consent, but it is abuse of the relationship. It is abuse of a fiduciary relationship that exists, right? And then you come to the next point, which is 376D. 376D deals with gang rape. Now, gang rape had also previously existed in the laws prior to 2013, right? And gang rape is when there are more than one person involved in the commission of a rape of a woman. And this is also an aggravated form of rape, so it has a greater level of punishment as well. Under 376E, you have repeat offender. If someone has been convicted of raping a woman and he does it again, and he's convicted one more time, this is an aggravated form, so the punishment can lead up to death, because he is a repeat offender. This is different than repeatedly raping a woman under 376(2). So there are two sides to this. One is repeatedly raping. Essentially, you're saying you're repeatedly raping the same woman. That gives you aggravated punishment under 376(2). But being a repeat offender, meaning that you have repeated maybe the same woman or different women, but you have already previously been convicted of rape. Then the second time you get convicted, you will, or the third time you get convicted, whenever, the second time if you get convicted, you can be convicted unto death. Your punishment can be death penalty, right? So after this, what had happened was in 2018, so 2013 was a very seminal moment in the criminal law, entire justice system, due to which all these laws were added. Subsequently, what had happened in 2018 was the Kathua rape case, right? It was a case of gang rape on a minor. So the government, and again, multiple protests started taking place. So the government, because usually the government is only moved to change laws or make it more strict only when protests take place and media comes into place. So what they did was they came out with the Criminal Amendment Act of 2018. right? So in 2018, there came a issue of adding more sections in to take care of minors in the cases of gang rape, because gang rape was not being covered under POXO. So you have to read POXO and 376D together, and they had made sure that 376AB, 376DA, and 376DB were added, where if the woman who has been raped ends up in a vegetative state and the woman is below the age of 12, then you have enhanced punishment that can lead up to death. It is mandatory minimum. It's mandatory minimum and then leading up to death. Same with 376D and DA and DB, which is 16 years and 12 years. Again, similar situation where if the woman is of the age of 16, enhanced punishment. If the woman is of the age of 12 and she has been gang raped, you have death penalty. So these are all enhanced punishments under the 2018 Act. So, but we'll come back to gang rape for a second, okay? Because again, these were all eventually enhanced. But gang rape is a very unique situation because the primary question that comes up is whether a woman can be prosecuted for gang rape. So you can see on this slide as well. You have the case of Priya Patel, 2006, and subsequently the Hemraj case as well, 2009. In both these cases, what was observed was that the intent of the law was to prosecute men. And because the definition of rape starts with when a man commits, you cannot have rape without a man committing it under section 375. See, 376D, gang rape, whatever it may be, it all emanates from 375. The circumstances of 375 have to be taken into consideration. So because 375 starts with a man rapes, then you have Priya Patel and Hemraj that comes into consideration. And they have very categorically stated that a woman cannot be prosecuted for gang rape. However, recently, there has been an Allahabad judgment, Allahabad High Court case as well, where they have interpreted 370 after the inclusion of 376D. There is the use of the term person. Disha, could you read 376D?
Yes, sir.
Yeah.
Section 376D, gang rape. When a woman is raped by one or more person consulting a group or acting in constituting a group or acting in furtherance of a common intention, each of those persons shall be deemed to have committed the offense of rape and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to life, which shall mean imprisonment for the remainder of that person's natural life with fine, provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim.
Yeah.
Provided further that any fine imposed under this section shall be paid to the victim.
So, and now, in addition to that, with the 2018, we know that the punishment can go up to death if the person who has been gang raped if the woman who has been gang raped is under the age of 12. Okay. Now, the Supreme Court has held that a woman cannot be prosecuted. However, there are certain high courts, and most recently it was in the Allahabad High Court, which held that because 376D uses the term persons constituting a group, this should include a woman. But ordinarily, as per the Supreme Court, woman is not to be prosecuted under gang rape. However, there is a loophole to this because a woman can be prosecuted for aiding and abetting, criminal conspiracy, aiding and abetting, and an interpretation of 34 can also be made. Usually, women are not involved in these cases, but aiding and abetting and criminal conspiracy can allow for some level of punishment to be given to the woman as well. But now, given that Allahabad High Court and I believe even Madras High Court to some extent at one point had said that, even though the Supreme Court had reversed that, but as of the latest position of law, the Allahabad High Court is saying that women can be punished under gang rape. But the Supreme Court has not said it as of the moment. But when the matter goes to the Supreme Court after the Allahabad High Court, hopefully maybe that can be included, and an interpretation of whether a woman is prosecuted under gang rape is done or not. We'll wait and see. But as of the moment, under the Supreme Court, women cannot be prosecuted under gang rape. But again, like I said, there are certain loopholes that you can apply for aiding and abetting. 34, which is furtherance of common intention, that you can use. Right? So we've covered all these sections. Does anyone have any questions? Another 5 minutes for questions of 376 and ABC to E. Tanvi.
Sir, what was the name of that case? Allahabad High Court one?
I was reading it on, I think it's Sunita Pandey, February 13, 2023. I was reading the article on Live Law. If most of you should also get a subscription. You get constant updates on that.
Anish, I think you can take the questions that are in the chat box because a lot
Let
of
me just see. Okay. Let's see. Oh, quite a few questions. Take them. Burden of proof shifted to two-finger test. Two-finger test is no longer allowed. Originally, one of the exceptions to rape was that medical examination will not constitute rape. But the two-finger test kind of medical examination was eventually held to be constituting rape, because two-finger test was deemed to be very inhumane. And it is correct. Shailendra Kumar was the case that was done. So in the two-finger test, they would try and see how far the penetration has gone. Because see, in rape, penetration is very important. Rape cannot happen without penetration. So any extent of penetration, there are judgments to that effect as well. Even 1 inch, barely, any level of penetration will constitute rape. What is the thing that is penetrating, whether it is the penis, whether it's an object, whether it's fingers, whether it's the woman's own fingers, these are all secondary issues. But penetration is primary. So they were holding whether or not the exception that medical examination will not constitute rape will be constituting rape or not. Eventually, the Supreme Court held that two-finger test is inhumane and should not be conducted, and it does not fall under the exception. However, you can use, say, medical tools. There are stirrups and there are dividers that ordinarily in medical legal examinations to remove, say, usually how they do it is to remove and identify if there are any sperm particles in the vagina. They cut like they cut out like a tiny portion. It does hurt, yes, but they cut out a tiny portion. They examine that under the microscope to see if there is any sperm particles present. It's like a pap smear, So using medical tools is still allowed. But the two-finger test was like a quick way to kind of tell whether or not penetration has occurred. But it was also not 100%, and it was inhumane because the woman, a woman who has alleged to have been raped is essentially being raped for a second time by a doctor. So the Supreme Court struck that down. Sakshas physically manipulate? Yes. As of the moment, it is physically manipulate any part of the body. 2018. Does the IPC apply to areas where martial laws are in operation? Yes, they apply to areas in martial laws are applying. However, martial laws, if there are any acts conducted by, say, the armed forces, they have their own courts that they'll have to deal with. So it will still fall, the sections will be of the IPC, but their prosecution will be taken place in their courts, right? And but AFSPA sometimes creates those exceptions as well, but it depends on what exactly is the law that is applied in that particular region. So because how it is applied and how it is prosecuted, because what is applied in, say, Jammu Kashmir is different, slightly, not completely, slightly different than what is applied in the northeastern regions. So that takes place as well. Burden of proof. What if power dynamic at play that made it difficult or impossible for the victim to refuse consent? If she cannot refuse consent, then we fall under this particular section, 376C. 376C, where consent is given, sexual intercourse is taking place, but there is a power dynamic that exists. Accused is in a position of authority over the victim, or victim was otherwise vulnerable or dependent on accused. It is rape. It will be considered rape under 376C. Because consent was given because the power dynamic was being abused by the person in a dominant position. So that is the answer to Manish's question.
But sir, my question is, sir, like earlier you explained that it will called as a sexual intercourse, not the rape.
Yeah.
So there's a two different terms.
Yeah, it will be offense under 376C. the exact words would be of 376C. Overall, it is still a sexual offense, right? So it is sexual intercourse by a person in authority. It is still a sexual offense. It is still a crime, but we don't call it rape per se. See, even the term rape now, it's very charged. It even in the Justice Verma committee, one of the major suggestions that they had was that we should not use the term rape, because the term rape affects both the woman and the man. There is so much stigma attached to the term rape, where if you say a woman has been raped, it's far more harsher. And if you call a man a rapist, it is also, and may or may not be a rapist, or maybe he was, or maybe it was in this particular position where he was someone who was in a position of authority. Is he the same as someone who's violently raping you? Can you put these two people in the same camp? So the term rape, they wanted to change to sexual assault. Completely, they wanted to change it to sexual assault. But the legislature was against that. They believed that rape should be called rape. Hopefully, maybe this might be changed in the future. But that is what it is, still a sexual offense, or an offense of sexual nature, even if you don't call it rape per se. Prakhar, you have a question? Go on. If she later on realizes that she has been raped in the name of meditation or any other processes, again, same situation. It will be considered abuse of position of authority. In the Guruji wala case, if it is a position of authority has been abused, if she later realizes, that is what is happening with a lot of these godmen as well. In some cases, the women are claiming that they were, say, violently raped, and in some cases it was because there was an abuse of the position of authority. And so if they are being actually raped under 376(2), it will become aggravated rape. But if it was consensual, then it becomes 376C. Prakhar, go on. I can't see Prakhar's question. Okay.
He said that he's heard you in the comments. And there are 2 new questions, I think, in the comments.
Let me just see. Actually, to realize, thirdly, fear. It's defined under 375. Thirdly, fear, read with section 90. We'll come to section 90 just now, after this, on the basis of misconception. Tukaram, burden of proof was on victim of prosecution. That is correct. This is why Tukaram is a very important case, because we didn't have that 114A at that point of time, where the burden of proof was, it was on the prosecution at that time to prove that the rape has occurred and that there was non-consensual. So thankfully, 376C covers this entire situation, where even if it is consensual, let it be consensual. You have abused your position of power, and you will be prosecuted for the same. 376D, we've already explained what is person, whether or not it would include a woman. It is the Sunita Pandey case. Whether or not rape is a crime of strict liability, one can say that it's strict liability, but ordinarily now in criminal law, we don't use necessarily terms of strict liability or absolute liability, because they are also dependent on the situations. There is some level of intention, but like I had explained before, when you use the term consent, to gain consent, your intention is there. What is your intention? How you gained consent? So there is some level, it's primarily to do with actus reus, with little to no mens rea. But in certain circumstances, there are aspects of mens rea that come into play. So especially in the circumstances if you're cheating the woman, if you are aware that she cannot give consent, it is a form of mens rea. Your sense of awareness, where you know that she is intoxicated. You are the one who has intoxicated her. The accused is the one that has intoxicated her. In those circumstances, there is mens rea that is involved. But primarily, it is still actus reus. Right? If a rape is committed by military personnel, can it be tried by ordinary courts? Depends on what laws are being covered. But special law will always trump. It will always trump your general law. And rape committed by military personnel, there are another secondary aspect of it, was the rape committed during the course of their military activities or not, becomes another question as well. So for example, similar to what we saw in the Kanwarpal case as well, it's IS officer, but even if it was a military officer, what we see is, if you are at a party and just because he's a military officer doesn't mean that it would be a different form of rape, right? Does he have custody over you? Is there a power over you? So if he's just because he's a military officer doesn't mean he will be prosecuted by the military courts, right? He would be prosecuted by the ordinary courts. If you say, for example, you met at a party and then he subsequently raped the woman. But if he raped the woman while she was in his custody, if he raped the woman while there was, some sort of organization going on or AFPA is present, then military courts come into play. Sir, if a person A aids the offenders and restricts the victim during gang rape, but actually didn't participate physically, she will be tried as equal offender or not. Again, similar situations, women can be tried only in this. Aiding and abetting, it depends purely on the facts and circumstances, whether or not Section 34 can apply. This is for Tanvi. Whether or not Section 34 will or can apply will be a matter of trial. And but usually what we do is we try to put it under 120B conspiracy or aiding and abetting. Now, again, Prakhar had the question, what about virtual? We've discussed virtual, Prakhar. So in case of intoxication, voluntary intoxication, see, again, voluntary intoxication is fine. Okay, just because the woman is voluntarily intoxicated does not mean it will automatically become rape. What matters is, was the woman intoxicated to such a degree where she was unable to properly give her consent? So if you as a man are aware that this woman is so drunk that she cannot properly give her consent, and then you have sex with that woman, it will be considered rape, even if she drank it herself. Okay, so the inability to give consent is where it becomes important. It is how far the intoxication takes place. A lot of times this is, especially after the Me Too movement, this has become a burning topic as well about, both parties are, inebriated. They both have alcohol. So, can you say that the woman is committing rape on the man just because he had alcohol? How can you say that the man is committing rape on woman just because she had alcohol? It actually doesn't matter if you have alcohol. It matters whether or not the alcohol has, firstly, if you were forced to have alcohol, that is one. And the second one is if the alcohol has, taken away your senses to such a degree that you cannot communicate consent, or the consent is not absolute. It still has to be unequivocal agreement, right? As the definition of consent is under 375. Without any threat, can a woman take screenshots of random video calls? I don't understand the question, Prakhar. She can take screenshots of random video calls. It depends on the nature, if it's sexual or not. If a man is forced to commit rape against his will and consent under the threat of death or to hurt him or to any person to whom he is interested, will the man be accused of rape? This is a very interesting question. I have not encountered any particular circumstance where this has occurred, but even in this situation, I would be of the opinion that rape has been committed, even if he was forced. At max, what you can do is you can commute his sentence, saying that he was forced to commit rape. What we will try to use are general exceptions, where there was a threat, there was a constant threat on your head that you will be killed or something like that, or someone you love will be killed if you don't commit rape. So it is a complicated question of multiple laws intersecting, right? Without any threat, can a woman take screenshots of random calls of a man and herself in appropriate position? See, screenshots are allowed. It won't be called rape. She can take screenshots. It won't be called rape. Screenshots are allowed. Again, if the man is taking the screenshot and he's disseminating it, if he's spreading it around, then that will be considered voyeurism. In none of these cases would it be considered rape. Again, as per the Supreme Court as of the moment, because manipulates body part is still physically manipulates body part is how it's being read. Okay. Can someone be charged for raping a dead woman? It's very interesting, Prakhar, that you asked that, because I asked the exact same question to my teacher when I was studying this question, whether or not necrophilia is a crime. Necrophilia is not a crime in India. You can't, raping a dead woman. It's because, again, a dead woman cannot give consent. Concept is not there. At max, you will be prosecuted for, say, grave digging or something similar in those circumstances. You don't have necrophilia as a law in India. Can a woman be tried for raping a man? No, it's the same situation. Woman cannot be tried for raping a man. A woman can be tried for raping a child. So in that circumstance, not rape, it's POXO. It's sexual offense against a child. So woman can be tried for that, but against a child. It won't be the man. Right? But rape under 375 will always be a man. It has to be a man who has to commit these acts. And again, based on our initial discussion, which is hopefully these laws change. But POXO becomes very important in this case because POXO doesn't use the term man, it uses the term person, which is why a woman can also commit sexual offense against a child. So now that we've discussed consent and we have a good idea of what consent is, I'll come to your question, Sudeep. Just give me a second. We have a good idea of what consent is now. Now, a larger question comes into play. What if the consent was given by way of fraud or some kind of misrepresentation? Disha, could you read again section 90 for us? Is Disha there? Anyone else? Section 90, please.
Section
90.
All right. Consent known to be given under fear of misconception. A consent is not such a consent as it intended by any section of this code if the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception.
Okay. So, Disha, what do you understand by this?
So this means that if the consent is given in fear, that is definitely not the consent itself, right?
Yeah.
It's under some sort of coercion or influence or any of the thing which mentally the person was not in a state of giving the consent, but was asked to give the consent.
Okay. So was asked to give the consent, but they were not capable of that. They were mentally not capable of that. This is a very important section because what the courts have done is that they have used the definition of consent under section 90 in addition to section 375, and they have stated that a consent that is given on the basis of misrepresentation of a fact will constitute rape. If sexual intercourse took place on the misrepresentation of a fact, it will constitute rape. The main portion of this is rape on the false pretext of marriage. The misconception of fact here, I'll give you an example. A tells B that you have sex with me and we'll get married. And on that basis, B has sex with A. Now, subsequently, A does not marry B. And then B files a rape case against A. According to the law, this will be considered rape. This has come to be known as technical rape. Okay? Because it's a misconception of fact. Okay? This has been come to know as technical rape. So this is a term that you use, whether or not it's technical rape. This is rape on the false pretext of marriage. Now, here, what's interesting is that, and because I've done nearly 35 cases relating to this bail matters or prosecution matters, right? It is so common now, especially right now. It's become very common where two people have consensual sex, and then the woman says that no, it was on the basis that I will marry. He promised that he will marry me, and so now it's considered rape because he's not marrying me, right? But again, there are so many nuances to this and facts and circumstances that are involved that change this and how to prove this. And I'll come to that. The main portion of it is what is the misconception of fact here? The misconception of fact here is that there was a promise of marriage. The woman was under misconception that the man will marry her. That is the misconception of fact, which is why when she gave her consent incorrectly believing that he will marry her. And that is why she had sex with him. So this creates that sense of misconception of fact on the false promise of marriage. Now, the second word that is important here is false promise of marriage. false promise of marriage is important because what had started to happen was that lots of women started to file cases against the men saying that, oh, he promised that he will marry me, now he's not marrying me, but we had sex, so it is rape. Because India sadly is a country where it is easier to say that a man has raped me than it is to say that I voluntarily had sex with a man. That is the sad situation of affairs, because voluntarily having sex is still considered to be stigmatized compared to saying that, oh, he raped so a lot of women started coming to courts and saying that, no, he raped me and now he's not marrying me. So essentially what they wanted was this man to marry them. What the courts eventually decided was that it needs to be a false promise of marriage. False promise of marriage means that the man never had the intention to marry the woman. That is what is important. He had malified intention at the time of having sex with the woman. The intercourse took place for two reasons. One, based on the man's expression that he will marry her, and he never had that intention. And second, being the woman has agreed to have sex with the man only because he promised that he will marry her. Does everyone understand this? These two concepts?
Yes, sir.
Right?
Yes, sir.
No doubts about this.
Yes,
right?
sir.
Both ingredients have to be fulfilled. The woman has sex only because the man promised her, and the man promised her on misrepresentation. He never had the intention of marrying her. So the first case that dealt with this was Uday versus State of Karnataka. That is where this concept was really evolved, even though somewhat the concept existed since the 80s. But the primary case that Supreme Court dealt with was in 2003. In this case, actually, the Supreme Court had said that, no, this is not rape. You are well aware. When you engage voluntarily in sexual intercourse with a man, you are well aware whether or not he is going to marry you, not marry you, whatever be the situation, you engaged in it voluntarily. It does not constitute, the ingredients of 375 are not fulfilled, so it is not rape. This was then reversed in 2005 in the Dileep Singh case. And Dileep Singh case established this, that it is a misconception of fact. But after 2005, again, like I said, multiple cases started being filed. So the courts had to come up with an actual guideline as to when will it constitute rape under false case of marriage. For that, the two cases that you can see are Deepak Gulati and Tigga wala case, where you see that it is a malified intention. The malified intention has to exist. That malified intention being no intention to marry since the beginning itself, right? And in the second case, the Tigga wala case, what the question was they were in a 4-year relationship, and then the man had promised to marry her, and then subsequently didn't marry her. So the court was of the opinion a man is allowed to change his mind. You engaged in a 4-year relationship, but you were not constantly having sex with the man on the promise that he will marry you. You were okay with a 4-year relationship. So it will not constitute rape. So these cases where technical rape has so many considerations and so many factors. So one of the cases that I had done was where it was a married woman saying that an unmarried man has raped me because he promised that he will marry me. So this was at the stage of bail. And our argument was that and we found case laws to the same extent, which is that a married woman cannot say that she was raped on the false basis of false promise of marriage, because she is already married. It is impossible for her to have even thought that this A will marry her, because she was already married. So this became a very humorous situation, and the court was also of the opinion that how is the woman saying that, oh, this the man who's allegedly raped me will marry me eventually. It's not unless you get a divorce that you show that you are no longer married, and then there is a promise of marriage. Only in those circumstances can that happen. So that is one of the circumstances where a woman who is already married, can she claim rape in this situation? And the answer to that was no, she cannot claim rape on the false pretext of marriage. So for example, a lot of times a lot of adultery also takes place. Adultery, what we find is married man and married woman. And the married woman says, or maybe not married woman, you have a single woman and a married man, where the married woman is aware that the man was married. In that circumstance, can she say that, he has raped me on the false promise of marriage? In that, the court was of the opinion no, because you were aware that he was married. However, if the man has concealed the fact that he was married and then had sex with the woman and said that, no, I will marry you if you have sex with me, in that circumstance, yes, it will be considered rape. So each factor is important. But like I said, those two guidelines are very important. Is that he needs to never have had the intention to marry her. And secondly, she only had sex with him on that promise that he will marry her. Okay. Does anyone have any doubts with regarding to this marital, with the concept of promise to rape? Promise to marriage, rape according to promise of marriage. Any questions?
I think we can discuss a few illustrations here where I'd like to ask the class if they are of the opinion if it's, marital rape or not. So if A indulges, meets B, and let's say A promises B that, okay, I will marry you, and they develop relations. If they develop relations and, over time they have had this association, and now this woman becomes pregnant, and this man says that, no, I don't have the ability to marry you right now, and I do not think I can raise a child and I can do this. So now this woman goes and files a complaint saying that, it was on the false pretext of marriage. Do you think it is justified to say that she was raped or not? I want the answer from you guys. Is it rape or not? A meets B, indulges in sexual intercourse. And now let me give you a situation also that, whenever we go to questions of false pretext of marriage पे जब हम rape में जाते हैं, हम हमेशा एक factor, like Anish also pointed out, that inception पे जाते हैं कि क्या inception से from the very beginning was it the intention was to not marry this woman, give her the misconception that the person will marry her, and then the relations are developed, or in unforeseen circumstances happen and could not marry her? Was the promise made just to develop sexual relations, or was the promise a general, okay, we like each other, we are, building relations and we might get married? So now I'm giving you a situation where A and B meet, they indulge in sexual relationships. During this course, the man has also promised the woman that he will marry her, and she gets pregnant, and he doesn't want the baby, and he says that I cannot marry you right now. Will you say that this was rape on false pretext of marriage or not? If yes or no, justify it.
Ma'am, no.
Okay, why no?
Because ma'am, from inception, means initially he had this intention to marry her, but now the circumstances have become such that he cannot fulfill his promise.
Yes,
And
Akash.
ma'am, also because there was consent right from the beginning from both the parties. Both the parties engaged consensually in whatever act they were doing, and uh, corresponding to the circumstances, eventually the inability of the man resulted in not fulfilling his promise. So that is different from his intent to not marry.
So what if the person at the very beginning said that, okay, we are meeting, we are indulging in a relationship, it will eventually lead to marriage. Now let me give you a parallel example as well. A meets B, okay? And now what happens is that this man is a married man already. Okay? In the same situation, this man
Okay.
is already married. And what he does is he meets a woman, tells her he's unmarried, tells her that same thing, that he builds relations with her and wants to marry her. And this woman gets pregnant. He tells her that, please abort the child. I don't want you to keep the child. And, and he also goes on to tell her that I do have a wife, I do have this so and so. And let's say even if he says that I will leave them and I will marry you, he maintains relation with this person. Is this rape? You will say it is rape at the very inception because this man was married.
Yes,
You
ma'am.
cannot say कि वो future में आया और उसने बोला कि नहीं अब मैं शादी नहीं कर सकता based on present circumstances. If at the very inception this person was already married, that means he had no intentions. If he had no intentions to marry her, and even if he was developing relations saying that I will marry you eventually, that means he was committing rape. So this illustration within itself comes as a question in your question paper lots of times. No, in both of these cases it was not rape. In the cases where he is a married man, it is rape. All right. However, in a lot of cases where the person promises to marry does not follow through, if by the trial and facts and circumstances, it is proved over time that this person from the very beginning had the intention to not marry, which could be, there are so many circumstances involved in such sensitive situations. अगर ओवर टाइम आप जाके ट्रायल में प्रूफ कर सकते हो कि मेरी इंटेंशन पहले थी, ड्यू टू circumstances I'm not able to marry, very good, you will get the acquittal. But if you are unable to prove so, that I did not have any such reasons, didn't lead me to not eventually marry her, and I had not made any such, the promises made by me were, in fact, I wanted to marry her, but nahi ho paya, whereas my promises were false, it is on you to prove so.
Yes.
If based on facts and circumstances आप prove नहीं कर पाते कि आपने जो promises करे थे वो initially सही थे, you will be held liable under rape. So this is a very subjective question. Now if the question comes in front of you, how do you answer it? Is that you justify your answer, which means you can also write it in parts that if it is proved that the promise was there, it was true, subsequently they indulged in sexual relations, it was a consensual relationship where they both agreed to have it, and even the woman has the ability to know that if they will indulge in maybe unprotected sexual intercourse, she might get pregnant. In this case, that the man over time, it is just about a relationship, cannot be held liable for rape. But however, if the person was already married, at the very beginning had no such intentions, it is rape.
Yeah.
All right, please make a note of it. This is usually an illustration based question. I have in the notes also mentioned the same. All right, now I'll let Anish continue, and we can take up the questions also. Yes.
Yeah. So adding to what Smriti said, she's completely correct. It is based on facts and circumstances. So even if you get a question on that, what you should, one is read the question very carefully and also try and fill in the gap if you can, which is give an answer which is elaborate enough, which takes into consideration all facts and circumstances. Because what is important is also how long have they known each other? How long have they been engaging in like practical sense? How long have they been engaging in sexual relations? Was there a relationship that turned sour? Or was there misrepresentation since the beginning? If he was a married man and he hid the fact that he was married and then he's promising to marry another woman, it's a misrepresentation. It is fraudulent in nature. His intention was malified. So you use these cases for that example. You use the Gulati wala case for that example. And there are multiple cases of this nature, but I wanted to also look at some, recent, more landmark cases. But you can search multitude of cases that are present for this. So false promise of marriages with respect to this. Now, we can conclude this with respect to 377. That is also a burning topic as we had started with it as well. Now, in 377, it provides cases of unnatural sexual offense, unnatural carnal intercourse. Now, prior to recent Supreme Court judgments, unnatural carnal sexual intercourse used to deal with two aspects. Primarily two aspects. One is homosexual intercourse, and the second is bestiality. Bestiality is having sex with animals. Okay, regardless of how you're having sex with them, having sex with animals was considered unnatural offense. Right? It's illegal. You will be prosecuted for that. Homosexual intercourse. Even though 377 includes all types of intercourse, it was primarily affecting the homosexual intercourses. Okay, when I say all types of intercourse, I mean all non-penile, non-vaginal intercourse. So oral sex, anal sex, all of this was being covered under 377 between consenting adults. Okay, between consenting adults, if they, engage in sexual activity, which is oral sex or anal sex, man and woman, it would be covered under 377 prior to the judgments. However, the main people that were being affected by this were homosexuals, which was man and a man. Primarily, it was man and man, or transgender, because we have a significant transgender population as well. a transgender person, who prior to their recognition as transgender were usually identified as men, so it would become a man having sex with another transgender would become man on man. Usually that would be anal sex, and it would be covered under 377. So a lot of transgenders, a lot of homosexuals, the entire LGBTQ community was being persecuted because of this law. So in Delhi High Court, NAS Foundation, that's an NGO, they had initiated a case to decriminalize this 377. And finally, Delhi High Court was of the opinion, yes, this should be read down and it should be decriminalized so that homosexuals and the LGBT community and transgenders can engage in consensual sexual activity without being prosecuted under the act. This was then overturned in Suresh Kumar Kaushal by a division bench in the Supreme Court, where they were of the opinion that the Delhi High Court has relied too much on a lot of international laws and international statutes, and this does not, it does not apply to us. Simultaneously, the division bench was also of the opinion that there is a very minuscule population, only 2% of the population is being affected by 377. So, it doesn't matter as much. So they used a lot of, I would say, they had the intention to never decriminalize it. However, this eventually went to a 5-judge bench, constitution bench. And the 5 judges, they were of the opinion that 3-2 split, but they were of the opinion that the matter should be, the 377 should be decriminalized with respect to homosexual intercourse. This was the Navtej Singh Johar case, which is also mentioned in the slide. In the bottom right corner, you can see all the cases in their chronological order. For that, what was decided by the Supreme Court, again, landmark judgment, what was decided by the Supreme Court was that, similar to how I had explained the independent thought versus Union of India, there was a reading down of the provision. The entire provision was not struck down as unconstitutional. What was read, so the provision was reinterpreted and read down to mean that having unnatural sex with animals is illegal, and having unnatural sex without consent between adults without consent is against the law. That is where you will be held guilty. So it meant that men who want to have sex with men who are both adults and give their consent, or women who want to have sex with women who are both adults and want to give their consent, they will not be prosecuted under 377, as it was the position before the judgment. But after the judgment, they will not be held liable under 377. Right? Does everyone understand that? Good.
Yes, sir.
Yeah. So within this, I'll make another distinction. Already, oral sex and anal sex has been covered under 375 now, post 2013. So when 377 was decriminalized, when 377 was read down, it included what was under 375, and it included crimes for LGBTQ community. So if there is any sexual offense, proper rape that is taking place in the LGBT community, 377 will apply. Prior to 2013, before we had these 4 descriptions under 375 of anal sex, oral sex, all of that. Before that, when someone wanted to accuse another person of rape and it was non-penile vaginal, they would also add 377 to that. So if the rape has occurred, it fell under 377. After 2013, because 375 has become so elaborate, everything falls under 375 if it is between a man and a woman. 377 is not used for rape between a man and a woman anymore. But rape between homosexuals will fall under 377. Consensual sex with respect to homosexuals will not fall under 377 anymore. And based on that, now the present Supreme Court case is also going on with respect to whether or not there should be same-sex marriage, because on the basis of that, whether or not any laws have to change. Because once you interpret 377, you decriminalize and you allow homosexual sex to occur, and that is held not to be a criminal act, then you must provide them other rights as well. Right? I think we can move on. One more major. Okay, Ruchi had a question. Ruchi, go on. Okay, I don't know what Ruchi's question is. Fine. One thing we'll just come to quickly is the Gurmeet Singh case. That's also part of your course. So when you're explaining rape, you should also go through the contents of the Gurmeet Singh case. The primary portion of the judgment was how rape is a very inhumane act, and the Supreme Court took a lot of sympathy on the victims and was of the opinion that, you know, ordinarily in trial, what we see when we cross-examine a woman who's the prosecutrix, who's the person who has been raped, there's a lot of humiliation that is involved, you know, because you are so desperate to disprove the rape, you humiliate the woman, and the courts don't take a very active role in this case. Only the prosecution and the defense, they go, it's a very aggressive, very adversarial system. So it really re-traumatizes a woman who has been raped. So in the Gurmeet Singh case, the court had laid down certain guidelines about how, you know, the woman shouldn't be humiliated, how the court should take up more of an active role in cross-examination, because if the defense counsel is trying to humiliate the woman or is questioning the character of the woman, this should be, you know, this should not be allowed. Questioning the character of a woman is also not allowed under the Evidence Act now. Similar to that, the court took sympathy on the victim and said that, you know, the effect of rape is constant, and the mental trauma that rape causes continues well beyond the act itself. Throughout the trial, it will continue. Simultaneously, there's a very interesting thing that happens in trial. One of the ways that we try to disprove rape is we say that the FIR was filed at a very delayed stage, essentially questioning the intention of the woman. What we say is that, why did she wait so long to file an FIR? You know, if she has been raped, allegedly, then she should immediately file the FIR. So that is usually a very strong point in disproving rape cases, because the way you prove a rape case is you file the FIR, your medical legal examination is taken place, and, you know, certain acts come out in that, whether or not there is forcible entry, whether or not there is, you know, any sort of sperm particles that are there. So you need to immediately report if you have been sexually assaulted in that way. So because there is delay, we use delay. I think Puneet's camera should be off. Yeah. We use delay as a tactic, essentially. And so the court, thankfully, the court was also of the opinion in the Gurmeet Singh case that don't use, just because the FIR is delayed does not mean that rape did not occur. Rape did occur. Rape may have occurred still, but you cannot use the fact of a delayed FIR to say that no rape has occurred. It is a mitigating factor, but it covers almost, you cannot solely acquit a person on that basis. You need to know about sexual offenses. Generally speaking, you can also read some other offenses like kidnapping, 363, procuring of a minor child, 370, human trafficking. There are, you know, laws relating to that. You have PETA, that's immoral trafficking, eventually became prevention of immoral trafficking of a woman. All of these aspects are also there. But with respect to your course, this is what, especially with respect to what Smriti said, your question answers, this pretty much covers everything. And I will share this slide with Smriti as well. So I think, you know, as a pointer, you can just have all of these details in the case laws.
And as far as our case material cases, I think I've made very particular specific notes on them, and Anish has mentioned them throughout the class. If you guys want, when I take the next class with you, I'll take about 5-10 minutes to discuss the cases I've already sent you in person. And that's about it. Any questions, Anish can take them up. And after that, I'll take the attendance. And yeah, please ask the questions if you want to.
I'm also looking at some questions here. Rape, strict liability. Strict liability has already been dealt with. There is some aspect of mens rea that is involved. You cannot say it is purely strict liability, but ordinarily it falls majorly in a strict liability category.
Especially if it's of a minor.
Yeah. In the case of a minor, it's always strict liability. If you have sex with a minor, it's always rape.
And,
There are
and
no
you know,
exceptions.
it is a little bit of a conflicting thing as well, that in one place you'll see 18 years and some place you'll see 16.
Yeah.
So that is very conflicting, but usually हम minor को हमेशा पॉक्सो में ले जाते हैं,
Yes.
क्योंकि वो एक stringent law है heinous offences के लिए. और ऐसा नहीं है कि just because IPC में 18 है वहाँ minor है, you go with, like I always tell you, जब भी criminality की बात आती है हमेशा सबसे stringent punishment पे ही जाते हैं.
Yeah, that is true.
So yes, even if IPC will talk about strict liability offence of statutory rape, it will 99% be, the
Under
trial
POCSO.
will go under POCSO.
Yeah. And
Yes.
POCSO also provides guidelines for how you deal with these cases.
Yes.
Even though you have good speedy trials with respect to rape, POCSO has a separate court for it itself.
Yes.
Where the child is, they have a special person that is appointed to help the child. The child is then put into a care home so that they don't have to interact with the accused person, because in these cases, usually the accused person is a relative or someone in your proximity. So you have to make sure that the child is kept away from them. So that is done. Umesh had a question.
Yeah, and the procedure also is very interesting in the trials of POCSO and these cases, because I had this case where this little girl, what happened was that someone paid her grandfather and told the grandfather that you make your granddaughter accuse a third person of rape. And this girl was also told that you please insert a candle inside your private part so that the medical examination will say so that, some sort of sexual offenses were committed against you and so on and so forth. It was a very interesting case. And, ultimately what happened, that girl was like that she was very hostile. She did not want to answer whether she was raped or not. In her first statement, she said that, yes, I was raped. Then the whole trial was conducted. कोई CCTV footage नहीं था. No corroborative evidence. And then she said that no, someone came and paid my grandfather. Eventually, she was placed in a care home. Eventually, now she says that I don't want to be a part of the trial and I don't want to meet my parents. I don't want to meet my family and I don't want to put allegations of rape on anybody. But that's the good or the bad part about a rape trial also. कि उसमें आप कहीं जा नहीं सकते हो. वो trial will be conducted. POCSO cases rarely happen. I have never seen it happen. When a rape of a minor is conducted, no matter what, the trial will be conducted.
Yeah,
and even I have seen people where, rape allegations are, they're alleged on the accused, and ultimately they get back together also sometimes. Truly. But they cannot withdraw the case.
Yeah.
They get married. They get married also. They come to the court together for the initial trial where the woman had alleged rape against the man. और पहले के जमाने में ऐसे भी होता था कि वो कहते थे अच्छा शादी कर ली तो हम ट्रायल खत्म कर देंगे. But because what started happening was that people started raping women and then they said, okay, we will marry her. So the court was saying, no. Even if you marry the woman, now you don't get the benefit of it. We don't know whether it was a coerced marriage or not. So now we will continue the trial. So with rape trials, first of all, and also another part about rape is that, the allegations of rape, minor mein to fir bhi police is very helpful and instantly will register a case. But now because of so many false rape cases, the, victim is also grilled a lot over time. In one of these cases of the case material also, they always question you, why is there delay in FIR? कभी-कभी तो ग्राउंड भी डिफेंस वो यही लेते हैं डिफेंस में कि इतने इनको 1 साल बाद याद आया that they were raped. This is also very big defense taken. But ultimately, because the law is all these sexual offences laws, what is the purpose? I always talk about the purpose. It is to safeguard women, right? It is to maintain the decent behavior when it comes to women, when their modesty or that they, no sexual offences should be committed against them. It is to do so. So therefore, law still maintains a very, I would say, like I said, it is a little biased towards women in these situations. But because of the number of false rape cases that have come about, because I see a lot of times that property issues may, both the parties, what will they do? They will put some sort of sexual offences on each other. कि इसने तो मेरी बेटी को छेड़ा, इसने मेरी बेटी के साथ sexual harassment की.
Divorce cases
every divorce case, people will say that, oh, I was sexually harassed by my father-in-law, by my brother-in-law. So now sexual offenses have sort of become vengeance, oriented as well. But still, we cannot get away from how strict they are. We need to keep them to safeguard women. But now, at the very initial stages, women are also questioned heavily. So yeah, that's about it. I will take the attendance. I see some people are very desperate for it in the chat box. So I'll do that. And I will take section J's attendance first. And I will go roll number wise only. What you can do is that when I ask you, specifically when I ask you of this page to this page, you can tell me your roll number. Also, the case material cases, the first case is not a part of, it is a part of your case material, but when it comes to question of rape, no, the first case is not a part that will come in your question paper person, because वो 354 से related है, right? But the next two cases, I believe, are from the very particular case of the offense of rape. And after that, also the two other ones are not a part that you need to specifically write in your answer. So now you see whether what sections apply there. And although we just have two cases relating to the offense of rape in our case material, I recommend writing at least 3-4. Ek to you can very well write the Nirbhaya case. And otherwise, in my notes, I've mentioned a couple, but write Nirbhaya and the Tukaram case and one more that is mentioned. All right. If any questions, I think they're over though, you can still ask Anish. And then I'll take the attendance in 2 minutes.
Sneha.
Yes, sir. I had a question regarding rape on pretext of marriage. You told us about this relationship that lasted for 4 years, right? And you said it wasn't rape. So, sir, my question regarding this was if initially the relationship started off like pretty naturally, organically, like how relationship is, eventually it fizzled out, and the man was like, "This is a great opportunity. I'm getting sex. Might as well tell her I'll marry her, and I'll enjoy the sex for a while, and then once I'm done, I'm done." So, what happens then?
In those circumstances, it would be very hard for the woman to show that it would be false promise of marriage because they've had sex. Because again, here it will become important because the man can show that he's been having sex with the woman constantly because they had a previously existing relationship. And the woman cannot show that she had sex with him only because he promised marriage, because it was a naturally established relationship. So if you go about it on paper, a case for rape can be made out, but its ending is going to be acquittal.
Okay, sir.
Yeah. Any other questions?
So,
Sudeep?
hello.
I think Sudeep has. Yeah, Sudeep.
यस सर, मेरा क्वेश्चन ये है कि आपने कहा कि अगर कोई एडल्ट वुमन एक मतलब चाइल्ड का रेप करता है तो उसमें एक इस प्रोविजन के अंदर हम डील कर सकते हैं, लेकिन व्हाट अबाउट एडल्ट वुमन रेपिंग ए एडल्ट मैन?
Adult woman raping an adult man is not rape.
I mean,
unless
there no provisions in the law?
I'll give you an example. Again, ordinarily law does not take that into consideration. Adult woman cannot rape an adult man under 375 or 376. However, an adult woman can rape an adult man under 377, but so far there is no case of the Supreme Court of such a nature that has come up. So it has to be the man is being anally raped by the woman.